All right, everybody, we are recording.
Okay.
We are going to get started right now. I'll ask you to mute yourselves. And we are going to talk today about NABOR contracts. So just as an initial matter, again, make sure you mute yourself. And if you want to ask questions, feel free to unmute yourself and ask your question. I've got the chat up so I can see and monitor that as well. I don't have a huge staff. I'm a one-man show, so I will answer questions as fast as possible. I do encourage you to ask a lot of questions because the more interactive this is, the more everybody learns. So let's get started now. Because I am an attorney, we're going to get started with a disclaimer. Anything that I say here, you cannot hold against me in a court of law, but it will be correct. All right, so a little bit about me. My firm was started in 2007, and we focus on real estate and business law. We do litigate in our office, and so we can, if we get into deposit disputes or other issues, we can handle those. We have offices throughout Southwest Florida. I have been practicing since 2003. I serve on the Legal Resources Committee with some of the folks on this call, and I am a recovering politician, so you'll have to excuse the jokes.
It's horrible.
All right, so today we're going to go through the NABOR contract. We're going to do some comparisons with the FAR and some of the addendums. I'll tell you right now, the Legal Resources Committee just is finishing up, putting the finishing touches on their 2021 contract changes. So where applicable, I'll mention some of those. Of course, I want to save the best parts of that for the legal resources classes, which you can get credit for. So I hope that you all will join those. I'll be teaching some of those classes as well. But I want to dive right in so I'm not wasting your time at all. And we're going to start with the contract. Right at the top of the contract, seller, buyer, address. So this is so basic. Why would I put this on a slideshow? Well, let me tell you, it's very easy as a realtor to know who your buyer is. Bob and Judy Smith walk up to you and tell you they want to buy a house. You show them some houses, and maybe you check their driver's licenses. You put their name on the contract. You get their address from them, and all is great on the buyer side. What about your seller? You're making an offer. You want to make sure that the seller is bound, that you have the correct party. You go to the appraiser's website, you look up who the seller might be, and lo and behold, it's a trust or an LLC, or it says et ux, which means somebody has died, or it says the estate of, which means somebody has passed away. And you're like, who do I put on this contract as my seller? You contact the listing agent and they give you names. They don't tell you the authority for which that person can bind the entity or the estate or the trust that is the seller. You got to get the right parties. Otherwise, you're going to have an invalid contract and your buyer is not going to be able to enforce specific performance. Same thing when you're the seller, you don't want to deal with a party that has no ability to sell the property. You want to waste all your marketing dollars on that. So it's very important to know who your seller and your buyer are when you get started. Fill them in. Also, see where it says addresses. That is so important that you put the address on the contract, because that way it shows where we send service in the event that we have a lawsuit. So let's be very judicious about putting our addresses on the contract. All right, so what are you selling? You're selling real estate, real property. How do you get that onto the contract? You need to make sure that you have the address, the legal description, and any appurtenances. That is the garage, the cabana, the storage locker, the boat dock, the parking space. Now, I'll tell you, it is very, very important that you get the legal description and the address correct. And you say, wow, that makes so much sense. Well, I see it all the time where they don't always match. So you got to make sure that you go to the appraiser, you get the correct legal, that you get the address, and you check with your listing agent or your seller to make sure that any assigned or deeded parking spaces, boat slips are included. Now on the contract, at the top of the contract is a long list of included items. Note some differences from the FAR bar. In this NABOR contract, the washer and dryer convey. But just like the FAR bar, the personal property is deemed of no value. That's for the lender. So if your personal property is going to be transferred for value, for money, then we need to do a separate personal property transfer agreement. And that can be very important when your buyer is getting a loan. And you want to make sure that you do a totally separate contract with an inventory and don't even include that in the contract, in the sales contract for the real estate. Okay, I'm getting a couple of questions. Therese says, do you use the address of the property if they're not living there, or their permanent address for seller? Therese, the question, and Arles asked the same thing, the address is legal notice purposes. So you can use the property address, but the goal is to get legal notices to the buyer and the seller in the event of litigation. That's why that address form is there on page 1. So check with your buyer, your seller, and see whether they want to receive mail in the event that they get sued. And they can't say nothing because they're going to have to put something on there. Okay. Let's talk next about the purchase price. Pretty easy, pretty basic. Put your purchase price, put your deposit. Most people in this blank here, you can see where my highlighter is, I hope. Most people put 3 days after the effective date. That accommodates getting a wire to the closing agent. I think 3 days is pretty good. And then you've got your second deposit here, typically 15 or 16 days. This line right here, 34, line B of section 1, proceeds of the mortgage. This blank is so important, and people skip it a lot. They fill in the financing on page 2, but they don't put the number that they're going to use for the mortgage here. This is a huge hole that hurts the buyer if they don't put the amount of the mortgage, because then if they get approved for less than what's listed there, they might still be forced to purchase under the finance contingency, and that could hurt them if they're trying to get their deposit. So be very careful. If your buyer's getting a mortgage, fill in line 34. Then of course you have your balance of purchase price will automatically populate in all the major form simplicities and app files, so you should be good there. Let's see, questions. Maria asks, if personal property is not present, do you cross it out on the contract? No, Maria, you don't need to cross it out. If it's not, it says if any on the contract. If it's there, great. If it's not, don't worry about it. Bob, you're asking how much do you put down for the initial and the additional deposits? So initial deposits, 1,000, 5,000 for larger deals, 10,000. But I really encourage buyers and sellers to get more deposit money in for the second deposit, typically done after the inspections. And I would try to get your buyer or your up to 5 to 10% of the purchase price, unless they're getting one of the FHA loans, it's at 3.5%. And the reason for this is on both sides. One, the buyer shows that they're serious, so they're making a better offer. And two, for the seller, it shows that shows that the buyer has some skin in the game, so the seller can feel comfortable if there's a default, they're not going to be left out in the woods. And so I always encourage more of a deposit. Katya, you're asking about VA loans and how much of a deposit. Again, it depends on the loan product, but I would say the same guidelines apply unless they're getting one of those 90-10s or similar to the FHA, they do 3.5% down, or 100. If they're doing 100% financing, then obviously they're going to put very little down as a deposit, and the seller's got to make a decision whether they want to take that risk. Okay. So let's talk about here the offer and the counter offer. Now I should have mentioned this at the beginning. I'm going through the NABOR contract page by page from top to bottom. So to the extent that you want to follow along, you can grab the PDF out of the chat, or if you have it in front of you, and we'll walk through this together. And I'll make line number references occasionally. After the presentation, by the way, I will make my slides available in the chat as well. Jerry asks if washer and dryer stayed on the contract, but no washer on the property. It does say, Jerry, it exists it's whatever is in the property at the time of the effective date. So the date that the contract is signed is when all the personal properties freezes and transfers. Anything that's listed on page 1. Okay, so page 2 of the contract, offer and counter offer. Entering a revocation date. I'm going to just say right now, if you don't put something in line 42, you've committed realtor malpractice, and you run the risk of being sued by your buyer if they decide they don't want to purchase. You got to put a date in there. You do not for any reason, without serious consultation with your customer and their attorney, about leaving an open offer. An open offer is one where the seller could come back to you at any time and sign the contract and say, I accept, because you didn't put a date for revoking the offer if it's not accepted. And then, of course, the counter offers go 2 days unless you change the default. And that's on line 43. And now the effective date in the NABOR contract is different from the FAR contract, and this is important as well. It is the last date signed or initialed by either party. So this contract does not state the delivery date as the effective date, which the FAR says. In the best way I think to explain this is by contrast. FAR, seller has to sign the offer and deliver it back to the buyer, obviously through the agents. And the date that the buyer receives the contract is the effective date. The NABOR contract, again, you have to deliver the contract back to the buyer if you're the seller and you're accepting the offer. But it is not the date that it is delivered, it is the date that it is signed by the seller. So this comes up, and this happened to me last night actually, comes up, seller accepts 10 o'clock at night, signs the contract, dates it for November 10th, but it's 10 o'clock at night, so the listing agent doesn't send the contract until this morning. Well, the effective date was yesterday, so we're already in contract, we're already in the inspection period, we're already moving forward. So again, you still have to have delivery, but the effective date, paying attention to that date when everything starts, is very, very important. Okay. So let's talk about the closing date and time being of the essence. The closing date is the date stated on line 48 of the contract. It is not, when you write on or before, all you're doing is agreeing to agree to a new date at some point in the future, but you've already agreed to the last possible date, which is going to be the closing date, unless both parties agree to change it. So I see a lot of on or before, and then buyers say, I want to close as fast as possible. And then they get mad at me when I say, okay, let me check with the seller and make sure that date works for them. And they're like, no, I get a pick. If your buyer wants to pick a closing date on or before a particular date, we need some additional language in the other terms and conditions, which I can certainly help you draft. And I don't charge for stuff like that, just to come up with some quick language like that. Now, time is of the essence for closings only in the NABOR contract. What does that mean? What does time being of the essence mean? Time being of the essence means that the date in the contract is a hard date. If you miss a deadline, the contract, you're in breach of contract, the contract terminates, and of course, we then end up in a deposit dispute. So if the buyer is, say, late on their second deposit, what is the seller's remedy? If time is of the essence only for closing, the seller then goes to the buyer with a letter formally in writing and says, seller, you're in breach of contract. You failed to make your second deposit on time per the contract, and you have 1 business day or 2 business days to cure your breach. So when time is of the essence in the NABOR contract for closing only, all of the other deadlines, particularly the initial and second deposit, you have to give the buyer the opportunity to make those before you can terminate the contract. This is major difference from the FAR bar, where if the buyer misses, for example, again, their second deposit, the contract is over, the buyer and the seller gets the first deposit. So yes, Teresa, I do not recommend putting on or before. I recommend people negotiate a date and stick with it. Okay. Now, in the NABOR contract, the buyer selects the closing agent in all counties. This is another difference from FAR bar, where seller picks, seller pays. In NABOR, in Lee County, under the NABOR contract, seller pays, buyer picks. So be very careful there. If you have a buyer who wants to control the closing and you're in Lee County, I would recommend using the NABOR contract. And then, of course, the last part of this section 3 says that the property has to be left in broom clean condition and the entire property free of debris. What does that mean? That means that you sweep up all the junk that you left behind when you're moving and you don't dump on the back of the property. I bring this up because I've had the case where the seller dumped concrete on the back of a 5-acre piece of property in the estates before closing as they were cleaning out their shed. And the buyer came in, did their walkthrough, saw the dumping and said, no, remove this pile of junk before I close. And that was very interesting. If everyone can make sure that they mute themselves, I don't know how to mute everybody. I think I can do that. I'm just not sure how to do it. So please mute yourself and we will keep moving forward. Darlene asks, if seller wants to pay, can they? Yes, of course. You can write it in the additional terms, Darlene, that the seller could pay. Yes. Okay. Financing. So the financing under the NABOR contract is actually really easy. It's very different from the FAR bar contract. We're going to walk through section 4 here pretty quickly because it really is easy. If it's cash, great. Buyer pays cash. There's no protections from the Consumer Financial Protection Bureau, deadlines should the buyer decide to get a loan on a cash deal. So the buyer's got to hit the closing date, the hard close date. That can be an issue. So I always tell my buyers, if you're getting a loan, let's do a finance contingency. Let's not take chances. But some people want to make a stronger offer. It's a real seller's market right now. So I understand doing that. I've got clients that do that, and we work through those as fast as possible. If you're getting a loan, note that there is no default rate. It doesn't say prevailing, doesn't say market as a default in the NABOR contract. You must put a blank there on line 61. And I will say this also about the NABOR contract. We fixed this for the 2021 version. If you want a conventional loan, the checkbox is actually on a different line 59. So be careful which box you check. I see that mistake where people want conventional, but they check VA all the time. So if you're looking at the contract, I'll make sure you note that. Okay. So if you get a VA or an FHA loan offer coming in, make sure that you attach the FHA VA addendum, which is provided in your forms. It's in app files, it's in Form Simplicity, it's in all the good ones. All of our vendors at NABOR provide the form. So make sure that you use those addendums because it's required by the FHA and the VA. Okay, now under the NABOR contract, the standard is you have to make a continuing good faith and diligent effort to get the loan approved. And you have to comply with all the lender and CFPB requirements. That means you're going to pay for an appraisal, you're going to pay for a credit check, all types of stuff that the buyer has to do to make a good faith and diligent effort if they want to have the opportunity to terminate if they don't get their loan. Okay, Darlene is asking, reasonable interest rate right now, Darlene. Check with your lender friends. I'm going to say it's in the 2.5 to 3.5, maybe 4.5 for commercial, but low rates are very low. You should not call your title company, call your lender. You should all have good lender contacts. I'll give you a list of 10 good guys in Southwest Florida if you don't have one. I say 10 good guys, 10 good men and women who are really good lenders who can get you through a private loan, private lenders, institutional lenders, whatever you need. Yes, Darlene, you are correct. The realtor should not guess. You can go on bankrate.com. I believe they publish average loan rates there. Okay. So moving on about financing. So the buyer must affirmatively waive the contingency in writing, not like FAR where the 30 days or 40, whatever you put, and the contingency expires and the buyer loses their deposit. You could be the closing date, and I did this when I bought my house. I never waived my finance contingency. The seller never asked. And if my financing fell through at the closing table, I was getting my deposit back. So the buyer has to affirmatively waive the contingency in writing. And there's a form in the forms folders for this. There's a termination of finance contingency form that the buyer can sign and deliver to the seller. I strongly recommend that you use that form and not make it up or send an email. Use the forms, they're very important. Dan asked, in the FAR contract, does the seller get the first deposit if buyer misses the date? Yes, Dan, if the buyer misses, I assume you're asking about the second deposit or maybe the financing. If in any case where the buyer misses a date in the FAR contract, the seller gets the deposit. Cheryl's asking, does the buyer have to waive the financing contingency once approved? Cheryl, they do not have to waive the financing contingency once approved, but this is where it gets tricky because the buyer may not have affirmatively waived the contingency, but if they're approved, it's going to be tough to show good faith and diligent effort and then say that they're not able to close under the finance contingency. So the contract is a little iffy in that regard, and I'd like to work on that with the committee at some point in the future. So after the contingency period expires, again, we're talking about that good faith or denial letter for the buyer, but the seller has an absolute right to terminate. So typically it's 45 days. So on the 46th day, the seller can better deal the buyer if they've got another offer coming in that's higher or cash or something. The seller can kick the buyer out if the buyer does not waive the finance contingency. So make sure that you, when you've got your buyer, you're having a conversation with the listing agent, and if you need to waive that finance contingency, do so before it's up. Yes, Cheryl, usually you would want the buyer to sign the contingency waiver. Darlene is asking, under the FAR, the seller isn't entitled to both deposits if the deadline is missed. If the second deposit's made, you get both deposits, Darlene. That's correct. Okay. Moving again through the finance contingency in the NABOR contract, there's a 10-day window for CFPB compliance. So this is a very limited and narrow exception, and I'm going to read it to you so that you can hear it, and then we're going to talk about it for a second. If buyer waives this contingency and is unable to close on the closing date due to a delay caused solely by the creditor or lender and or necessitated by the CFPB rule, buyer may extend the closing date up to 10 days for CFPB rule compliance and to accommodate receipt and execution of the loan package and loan funding. That's it. Not the buyer's not ready, not that the buyer's not approved. If the buyer has waived their financing contingency and they get to the close date and the buyer is not ready, the buyer loses their deposit. If the lender is not ready, again, for CFPB TRID compliance or to get the documents signed, like a mailing issue, then there's 10 days to get that done. But people come to me, I've got 10 days, right, to close? No, you don't. It's a cash deal. I got 10 days to close, right? No, you don't. Your lender is ready to close and they're going to get the documents done on time. So you've got to be very careful there. It's not for the unapproved loan because the buyer was slow. Okay, other questions here. Cheryl, the buyer never signed it or acknowledged waiver once they were approved. Cheryl, you got to give me some context on that. I think you're asking about the financing contingency waiver. If the buyer hasn't signed it or acknowledged the waiver once they were approved, then there's still a contingency under the NABOR contract. It's different from FAR. Okay. Moving right along in the contract, let's talk about association and government liens and special assessments. This is section 6 of the contract. Section 6 is very complicated. It's 2 sentences, but it is a big pain in the rear. The seller pays the special assessments before the effective date. The buyer pays anything that's assessed after the effective date. How do you know if something has been properly assessed before the effective date? Well, there's a 3-part test in the contract. You have to have the identity of the lienor, the property subject to the assessment, and the amount of the lien. If you have all 3, seller pays the lien in full prior to closing. So what does it mean in the second sentence of section 6, where it says, I'm going to read this to you, if as of the effective date there are any pending liens or special assessments which are not seller's obligation as set forth in sentence 1, what the heck does pending mean? I'll tell you, I have so many conversations with realtors and other attorneys about this word pending. The pending assessments are those that are discussed by the board. They're discussed by the association at membership meetings, but have not been properly assessed yet. If that happens and the seller does not disclose, then the seller has to agree to pay everything over 1% of the purchase price, or the buyer can terminate essentially. Hold on, we have some more questions. Cheryl, you're asking again, about the waiver. Can the buyer just ignore? The buyer does not have to sign the financing contingency, Cheryl. They can go all the way to closing without signing it. It's on the seller to terminate if they don't like that. So that's that deal. Okay. I don't see any questions about pending. Usually I get 1 or 2 about those. Yes, line 79 of the contract related to CDDs. I did skip the CDD section, but if the property is in a CDD, you have to use the CDD MSTU. It's going to be the new CDD MSTU paper is no longer an addendum to the contract. We're changing it to a disclosure. That's because you need that document for both the listing agreement and the sales contract. So just note that in 2021, the new form is going to be a disclosure, but right now it's the addendum to contract for CDD. Okay. Irene is asking, how can we get the buyer to pay the assessments that are already assessed on the tax rolls? They're going to be assessed. I mean, when you say on the tax rolls, you mean, I assume you're not talking about the association dues. So they're going to pay them on their tax bill in the next year. So that's how those are paid. Okay. I see people. Make sure you mute yourselves, folks, especially if you're taking a call. Okay, let's move on. Leases. If the property is an investment property or it's a rental, you know, a summer rental or a seasonal rental, then you need to check the box in section 7. And it's very simple. The seller has 5 days to get the leases to the buyer. The buyer has 5 days to review, and the buyer can terminate if they don't like what the leases say. So it's a pretty simple process for leases. Okay, inspection. So we're going to talk in great detail about standard D in a few minutes, but just note that here, section 8 of the contract, you need to check what kind of inspection you want. The full inspection under standard D, the due diligence inspection where you attach the as-is addendum to contract. Don't check box B and forget the addendum. That's bad. And then, of course, you can always waive all inspections and just move to clearing title. Okay. Cindy, I don't understand your question, so that is a 10-day window. If you want to give some context, you want to unmute yourself, you can ask the question. It's okay. All right, so that covers the first part of the contract. We went through sections 1 through 8. Next, the rest of the contract, pages 3 through 12, are the standards. The standards, it says in bold language at the top, don't change the standards. Please don't make modifications to the standards without checking with your favorite real estate attorney. You can do a lot of damage and possibly, again, commit realtor malpractice. So let's be very careful. Oh, Cindy, you're asking about the leases. Yes, it's a 10-day window to review the leases. 5 days to receive, 5 days to review. So it's not more than 10 days to terminate under the lease provision of section 7. Okay, standard A. So standard A1 is an interesting standard because it says that the buyer gets marketable title. So buyers call me all the time. I want clear title. I want fee simple title. Realtors make this mistake as well. In Florida, you get marketable title. What is marketable title? It's a title that you can resell pursuant to the Florida title standards put out by the Florida Bar. Really simple and really complicated all at the same time. Basically, it's a title that the buyer can resell. Okay. Assignment of the NABOR contract are allowed freely. You have to get your closing agent the information for your buyer 15 days prior to closing. I can tell you, there's one lawyer in town in particular, but there are several that get sticky about this. If you try to change the name of the buyer through an assignment, make sure you've done it 15 days prior to closing to avoid somebody saying, well, I'm not going to redo documents or I'm not going to change it at this late date. Because anything has to update title and all types of things. And note that when the buyer does make an assignment, the buyer is not released from their obligation to perform. So if their assignee fails to perform, the buyer could be in trouble. Okay, and then the other thing here about in standard A, and I get this question quite a bit. Yeah, make sure you're muting yourselves. I'm muting people as they pop up, but make sure you mute yourselves, folks. 1031 exchanges. You do not have to write into the other terms and conditions buyer or seller is completing a 1031 exchange, or buyer agrees to cooperate with seller in 1031 exchange. That language is in standard A3, already there, ready to go for you, approved by most all major exchange companies. So don't worry about adding that. It's already in the contract. There we go. All right, standard B. Legal access, title evidence, and defects in clearing title. Oh, wait, we have a question here. Can the seller reject an offer to purchase based on the contract form? Of course you can. Jack's asking if the seller can reject an offer on a NABOR form and request a FR. Absolutely. Anytime. Seller's not obligated. Just pick your form and demand that it be used. Okay. So the seller has 10 days to deliver their prior policy. That's the policy they got when they purchased, or this contract penalizes the seller $150 credit to the buyer. There's 30 days for the buyer to examine title and determine if there's legal access. And then the seller has 30 days from the date the buyer gives the seller the title commitment to clear title. This may extend closing. I should highlight this. May extend closing. If the seller can't clear title by the closing date, they get 30 days from the date they received the title commitment, not the closing date, the date they received the title commitment to clear title. If the seller can't get it done in 30 days, the buyer has 5 days to terminate the contract or accept the title as is, which I never recommend. And of course, in the NABOR contract, it specifically says that the seller has to spend money and bring suits to clear title. So you may be in a situation where the seller is going to bring money to closing. They may have to sue somebody. They have to go to court, depending on the situation. So it's much more arduous than the FR because we want marketable title to pass at closing. Okay. Surveys. So the survey is so important. The survey is, hold on, Josh is asking, is the 10 days to deliver title or credit to buyer different from the FR? Yes, that's different from FR, Josh. That does not exist in the FR contract. Okay, so the survey is a very important document because the survey is the only document that ties the legal description on the deed to the plat map or the meets and bounds where the property is located. You know, you can show me a deed that might say lot 4, Happy Acres, Collier County, Florida, and I got to go to Happy Acres and look for lot 4, but I don't know that that's the correct spot because the deed isn't tied to a map. That's the survey's job. So the buyer may get their own survey up to 5 days prior to closing, and any survey objections are treated as title objections. So again, it may extend closing. Okay, so let's talk about standard D. Standard D, 4 pages of inspection issues. So standard D1 are the disclosures, the seller's disclosures, the mandatory disclosures, and the advisements and acknowledgements that the seller makes to the buyer. I'm not going to go through all of them because there's a lot. It's a page and a half worth. But the important one that affects you as the realtor is the Johnson v. Davis no material defects that weren't disclosed. So the contract parries the language of the Johnson v. Davis case, which I will explain to you in a moment. And it says in the contract, seller knows of no facts or conditions materially affecting the value of the property except those which are readily observable to buyer. What does that mean? That means that the seller is going to have to tell the buyer about any facts or conditions that affect the value of the property. Things like the roof leaks, but it doesn't come through the, didn't come through the drywall, or you painted over the stain in the ceiling, and now you've got to disclose that even though you tried to hide it. I see that all the time. I will tell you this about Johnson v. Davis. You as the realtor are liable for the seller's failure to disclose if you knew about it. So if the seller, you're walking through the listing, you're getting your listing organized, and the seller says, don't worry about that black spot on the wall over there, I'll get that taken care of. You need to make sure that that mold, which is obviously a big black mold spot, is remediated, or it needs to be disclosed to the buyer. If the seller runs a coat of kills over it and paints it and doesn't clear up the underlying mold problem, the seller is in violation of Johnson v. Davis. And if you as the realtor know about it, you are too. So be very careful. Katya is asking, would seller's property disclosure protect the realtor? Yes, if the seller properly discloses something, then the realtor will be able to take advantage of that seller's disclosure. But if you are told something and you don't disclose it, even if you're a single agent, you're going to be in violation of Johnson v. Davis. Okay, there's also a disclosure here that says that the seller does not know of any open permits to the property or of any improvements which were made without proper permits, certifications, or any existing violations of local ordinances or code enforcement violations. So the seller also has to disclose open permits and unpermitted improvements. If they don't, they're in breach of contract, they're going to get sued for damages. So be very careful about that as well. Again, that realtor, that liability may, though I've not seen this case, pass to you as the realtor as well. And then, of course, the HOA condo disclosures, there are two of them actually. They're in section C, D2C3 and D1C3 and 4. The mandatory bundled club memberships, you'll know, in some of your associations, the club is mandatory. The buyer needs to figure that out for themselves. And the buyer needs to investigate the community to make sure that they understand the insurance issues and everything else that comes with it. Okay, Darlene is asking, Irene is asking, for open permits, if they convert the garage to a beauty salon, do we just disclose? Yes, that's what you would disclose that. Josh is asking, if an issue is visual upon showing, is the seller required to fix it? Talking minor issues, not major, like grout missing in a shower. Josh, we're going to talk about that in greater detail in a few minutes. I'll get to that question. And then Darlene is asking, if the HOA meets, discusses, and passes a change, does the seller need to disclose, or is it up to the buyer? Darlene, after the contract is signed, it's on the buyer. Before the contract is signed, it's on the seller. And then Jerry is asking, do I need 2 HOA receipts signed if master association and condo association docs are both repped, not club membership? So we'll talk about HOA docs and condo docs in a few minutes, Jerry. I will get back to you on that one as well. Is the seller required to provide all HOA docs to the buyer, Marla? Okay, well, so HOA docs are not required to be delivered to the buyer unless there is an HOA addendum. NABOR provides an addendum to request HOA documentation, the declaration, the articles, the rules and regulations, similar to a condo, but they are not required in a homeowner association like they're required in a condo association. And we will talk about that in a few minutes when we get to those 2 sections of the contract. Bob is asking, when taking a listing, do you recommend having a seller get a pre-listing inspection? Bob, it depends on the seller and the property. If it's an old property or a person who's not, real involved in the property, then I would do an inspection, pre-listing inspection, yes. Okay. So I don't see any more questions coming in. So let's talk about standard D2. So I want everybody to know about the numbers 15, 5, 10, and 5. These are the deadlines in standard D2 for inspections. I'm going to say it again, 15, 5, 10, and 5. The buyer has 15 days to conduct inspections. The buyer has 5 days to gather their reports and deliver them to the seller. The seller then has 10 days to review the reports, conduct additional inspections or investigations of their own property, and respond to the buyer's inspection election. If the seller counters the inspection election or rejects the inspection election, the buyer then has 5 days to terminate the contract. 15, 5, 10, 5. So Paul's asking, why would someone sue over a permit? Why wouldn't they just work it out to close the permit? Paul, that's an excellent question. It's absolutely what I recommend. Work it out, do a credit, figure it out, but don't get into a lawsuit because that's just really expensive and wastes everybody's time and money. So that's how I would handle that, Paul. Okay, so in this contract, the buyer is entitled to 6 inspections. Different from FAR. You can do mold and radon under this contract, but you get systems, equipment, radon, lead-based paint, WDO, mold, and open permits. The buyer may request a credit or remedial action. If they request a credit, if the credit amount equals the cost of remedial action, not replacement. So for example, if the fridge is not working, the buyer is not entitled to a new fridge. The buyer is entitled to a working fridge. So if the fridge can be repaired for $150 service call, the credit is $150, not $6,000 for a new fridge. I mean, $2,000 for a new fridge. That gets very confusing for people when they see like a roof and the roof is just leaking and it's a mess and there's broken tile and all that sort of thing. The buyer is entitled to a roof that is structurally sound and free of leakage. So they get that fixed, but they don't get a new roof. I had this call yesterday where the roofers are telling the buyer that the roof is not salvageable, that it's not structurally sound. And the buyer is demanding a new roof. And I said, the seller only has to make the roof structurally sound and free from leakage. And the buyer didn't like that. But that's what this contract says. Okay, Cindy is asking, what are your thoughts on the verbiage repair or replace? Cindy, you have to give some context, but the contract says you get remedial action, which is more like repair than replace. And then BC is asking, used fridge can be substituted. BC, I'm not sure how you mean used fridge can be substituted. If the seller, I think you're asking if the seller wanted to replace the fridge with another used fridge, that would probably be something that needs to be negotiated with the buyer, because the buyer may be expecting the GE profile and you can't come back with the low end KitchenAid or something. Okay, so working condition versus cosmetic conditions. This contract is very detailed. Working condition is systems and equipment shall be deemed to be in working condition if operating in the manner designed to operate. What does that mean? Again, if the fridge, the disposal, the light switches, if they turn the lights on and off, they're in working condition. If the plate is cracked, I'm sorry. If the light doesn't turn on, then you've got a problem. Brian, do you have a question? Oh, no, okay. Cosmetic conditions, torn screens, broken tiles on the roof. What else is chips, dents, caulking, pitted pool surfaces, minor cracks in windows, driveways, sidewalks, pools, decks, garage tile line floors, and patio floors are all cosmetic. So if you've got a cracked window, like if the seal's busted and the window's kind of fogging up, under the NABOR contract, that's cosmetic. I believe under FAR it is not. So you got to be careful there. Darlene says older sliding glass doors, they work, but they're a bit difficult to open. So Darlene, actually, this is an excellent question. I get this all the time, particularly on Marco with the condos and the sliders, the older condo buildings. But if you're buying $1 million condo and the sliders are sticky, they're probably not in working condition. They need to be rolling fairly smoothly, especially if they're newer. If they're old, like those old aluminum doors and they're all crusty, and they stick a little bit, but they close and they lock, probably working condition, or I'm sorry, cosmetic item, because the door, it's an older door. So it just depends. Look at the situation, look at the condition of the property and the door, and you're going to have to fight about those sliders. I do that all the time. Paul saying is cosmetic arguable? Yes, it is. That's what I'm saying. Diane says with regard to the 15/5/10/5, does the time clock start the effective date of the contract or the day one being after the date? Diana, thank you. Excellent question. The first day of the 15 days is the day after the effective date. So if you are on the 1st and you sign the contract on November 1, November 16 is the 15th day because you start counting from day 2. I hope everyone gets that and understands that because you don't want to miss those deadlines. Josh is asking, what about something like a fan not working upon the day of execution? If a fan doesn't turn on, it's defective and needs to be corrected. So that would be a defective item. Okay, where are we at here? So if the seller is not able to complete all of the remedial action by the closing date, then this contract calls for a 200% escrow, and the seller escrows 200% of the full cost of the repair, not the full cost minus deposits made. Full cost into escrow. It's held for whatever time period the parties agree to. And then the repairs are made after closing, and then you close out the escrow. Okay, moving right along. So the buyer can conduct a walkthrough inspection. The walkthrough inspection in the NABOR contract is to look for 4 items. Completion of any remedial action agreed to by the seller, that items being conveyed are on the property, that items not being conveyed are off the property, and that the seller has performed their maintenance obligation, their remedial maintenance obligation as required. So the seller has an as-is maintenance obligation to keep the property as is, except wear and tear as of the effective date. And they have to make all the remedial action repairs. So if they don't do that, then you get into the 200% escrow. Okay, let me check my questions. Bob asks, if the fan is found to not work on the walkthrough on the day of closing, what do you do? Bob, if this fan was identified as not working, or if it quit working during the contract term, the seller's got to fix it. And if they can't fix it on the close, if they can't get the electrician over there and get it working, then you escrow 200% of the repair cost. Okay, standard D2E, risk of loss. So the seller has the risk of loss up through closing, including the landscaping. This is important, and we're talking, there's a limitation that later on in the contract, in the event of a casualty like a hurricane, the seller is limited to 1% of the purchase price for landscaping liability. But this is important if, like today, when ETA is coming through Southwest Florida, if trees get knocked over or things like that, the seller's got to replace them up to 1% of the purchase price. And it says in here, I should have highlighted it. Where is it? To the extent reasonably practical based on availability of substantially equivalent replacement landscaping. So if you're selling in Port Royal and the 50-year-old Royal palms come down in a hurricane, you can't replace those. Or maybe 100 grand each if you could, but you can't even get them because they're 100 feet tall and they're beautiful. And the seller would have to give a credit, in my opinion. This is not specific in the contract. It's another area where the contract needs work. But I would believe the seller would then just need to give like a 1% credit to deal with that. Okay, so let's talk about insurance and habitability. If you can't get insurance, like today, we're in the box because there's a hurricane outside. If you're in the box, you can't get insurance. The contract allows for up to 30 days for the buyer to delay closing to get insurance, and then you close within 5 days of the insurance being bindable. If the property is uninhabitable or uninsurable due to a casualty event, hurricane, fire, flood, then the buyer can terminate the contract. In the event of a hurricane, and it's apropos that we're talking about this today, and the day that there's actually a hurricane coming in, after the hurricane, the buyer can get another limited inspection to determine if there was any damage. Typically, this is for the buyer's lender to make sure that they're not loaning on a destroyed property, but you can get a third walkthrough type inspection after a casualty event. Okay, let me just check here. Any questions about inspections, risk of loss, standard D stuff before I move on? Anybody? You unmute yourself or you can type it into the chat. I want to make sure I get everybody. Okay. We're going to zoom through the rest of this pretty quick.
Sam, that 1%, does that also apply to remediable action on repairs?
The 1% is the limitation on landscaping only. So if the property, again, was determined to be uninhabitable or uninsurable, the buyer could terminate or the seller could have to repair.
Is there a cap on remediable action costs and repairs? Is there a cap?
No, there is not.
Oh, okay, good.
Can the seller's agent require you to submit an offer on a specific type of contract, Tina? Yes, they can. It's just up to the buyer whether they want to do that. Okay, let's zoom through the rest of this. We're already at the 1 hour mark and I want to make sure you hear everything. So the instruments and expenses are, of course, the buyer picks the title company in all counties. In Lee County, the seller pays for title. The seller pays for doc stamps. The buyer pays for doc stamps and intangibles tax on the note. And the buyer pays for the lien search, which is different from the FAR bar. Dan, you're asked about the 15, 5, 10, and 5. Dan, shoot me an email and I will go over all that with you afterwards. Darlene, yes, you can change in other terms and conditions, anything you want. Okay, prorations and credits. You prorate the taxes and the association dues. And when you sell new construction under the NABOR contract, where there's a lot, you prorate the taxes at 80% of the value and make a determination. And I will tell you right now, this happens a lot. Propane, if you got a propane tank, get your propane tank servicer out there to tell you how much gas is in the tank, or the seller is going to lose their credit for that. Rents are prorated and security deposits are transferred when you've got a lease situation. Okay, so standard H&I are the HOA and condo disclosures that are required by statute. Chapter 718 and Chapter 720 of the Florida statutes govern associations for condos and homeowners, and they're very annoyingly complicated. The HOA homeowner association rule is a 3-day right to void the contract if the disclosure is not provided before contracting. You don't need to provide HOA documents unless the HOA addendum is used. For condos, there's a 3-day right to void the contract at any time after the documents are delivered. So condos, you deliver documents. HOAs, you deliver an HOA disclosure, but no documents. Condos, it's kind of weird. The buyer gets to guess is what the association dues are. The HOA, the buyer has to guess what the documents say. So I recommend that you use the HOA addendum in the NABOR contract so that the buyer can see, has a contractual right to review the HOA documents. When you're selling a condo or buying a condo, I recommend that you use the assessment worksheet that NABOR provides, and you disclose all the condo and club and foundation and management and beverage fees on the assessment worksheet that's provided in your forms folder. And please don't forget the condo governance form when you're selling condos. I have so many times, the buyer wants to get out of the contract. It's the day before closing. And I say, well, did you get your governance form? And the seller says, what's that? And then automatically it's a 3-day right to terminate and the buyer gets their deposit back. So be very careful about delivering the governance form. The governance form is in the forms folders on app files and form simplicity and everything. Make sure you include that when you are doing condo work. Okay. Standard J, the buyer has 10 days to make application to an association. If they don't get approved, either party can terminate. And the seller has to get the estoppels from the association and deliver them 15 days before closing. Now, this ground lease situation is new to the contract because in Naples, we're running into a situation where a lot of ground leases are coming up on 40 years. If there are less than 40 years left on the ground lease, the buyer can terminate under this contract. You're gonna say, Sam, where do I get this ground lease? It's usually recorded. Just call me, I'll get it for you. Maya is asking, the governance form protects who or what? Mariah, that's a great question. The governance form doesn't really do anything, but it's required under the contract. It is a form that identifies the certain condominium statute information to the buyer. Jerry is asking, do I get buyers to sign
put that
two
away.
receipts? One for HOA docs and one for condo docs? No, the HOA docs don't really have a receipt form. You just need to exchange emails with the listing agent. The condo co-op receipt form doesn't really accommodate HOA docs. Paul says, how do I know if there's a ground lease? Just call me, I'll find it for you if there is one. They're public records. Diane, did you have a question? Diane de Guzman? Okay. Somebody asked you, you will get copies of the slides. Sharon, did you have a question? I'm sorry, I see people unmuting themselves. If you have a question, just shout it out or put it in the chat. Vivian is asking, is the NABOR contract advantageous to the buyer or seller? It's a very balanced contract. It's not advantageous to either one. I do prefer NABOR over FAR when you're financing because I don't like the FAR financing contingency, but I'll tell you that they're completely rewriting the FAR financing contingency. It'll probably, new one will come out next year so that my comments may be updated. Bob is asking, why is polybutylene piping on the FAR disclosure but not on the NABOR disclosure? Polybutylene is not a defective item, Bob. If the pipes are made of polybutylene but they don't leak, they're not defective under either contract. So I don't know why it's on the FAR bar disclosure form. I don't think it should be. Okay. Okay. This is a very important term as well, standard K. If you've got a lender, the seller agrees to follow the lender's policies. So make sure that that the seller understands that. Oops. Folks, make sure you mute yourselves. Okay, standard L. The escrow agents are not liable. We can sue to determine the liability for the deposit if the deal fails through an interpleader lawsuit, but unless we make major mistakes, we're not liable. Obviously, that's important to me. So FIRPTA, I do a whole class on FIRPTA, so I will just tell you, FIRPTA is a buyer's obligation. They have 10 days under the contract to remit 15% of the purchase price to the IRS unless there's an exemption. There are 2 exemptions, one for properties under 300,000, one for properties under $1 million. It reduces the 15% depending on the exemption. And the seller holds the buyer harmless for the FIRPTA amount. That means that if the seller screws up and the buyer gets sued, the seller is going to get sued too. Okay. Let's talk about this hurry up provision. How many people here on cash deals would do a 60-day closing? I can tell you that nobody wants a 60-day closing on a cash deal. Typically, it's a 30-day closing or less. So the hurry up provision in standard N says that all those provisions in the contract for 15, 5, 10, 5, for delivering the title commitment, for everything else, get compressed in a short closing. And everybody is required to perform and get everything done by the closing date, except deliver condo and HOA docs, because you can't, those are statutory. I will also tell you something else about those HOA and condo docs, HOA disclosures and condo docs. You can't accept them as the realtor for your customer. They've got to get to the buyer, and the buyer's got to sign off on them. It's not like other agent issues where you can represent your customer and collect that stuff. And if you're the seller, make sure the buyer sees those documents in that HOA disclosure, or they have a right to void your contract. Okay, defaults and remedies. If the buyer doesn't perform buyer's obligation, all deposits go to the seller. If the seller does not perform their obligations, the buyer can sue for specific performance. That means take the property from the seller and the seller pays the buyer's attorney's fees. They can sue for damages, or the buyer can just walk away and get their deposit back. In the event of litigation, I get paid. The attorney's fees get paid by the losing party. So be very, very careful. Don't get into lawsuits. Almost every situation we can avoid if we're very careful about it. So there are a variety of notices, disclosures, and acknowledgments that are done throughout the contracting process. They all have to be in writing. Unless they're required to be delivered, you can deliver to the attorney or the broker. But just remember, like I just said, HOA and condo docs got to go to the buyer. You can't accept them. Very important. So all the deadlines in this contract expire at 11:59. This is different from the FAR bar, which has a 5 p.m. deadline when the deadline falls on a weekend or holiday and rolls to the next business day. In the NABOR contract, it's similar. If the deadline lands on a weekend or holiday, it rolls to the next business day, but it's 11:59 on the next business day. Also in the miscellaneous section, it says that all deposits go back to the buyer unless otherwise stated. So the buyer, by default, gets their deposit back. Okay. Negotiated terms must be in writing. The buyer agrees that they made their decision based on their own investigation. And then, of course, there's some protections for the realtor and the broker in the contract. Again, even more disclosures. Each party acknowledges that they had a chance to review everything, talk to their lawyer, and figure out the title issues. And everyone and the buyers are advised to consult legal and tax and environmental consultants.
Now he's already getting tea.
Hello. Yep. Kathy, do you have a question?
Oh, no, sorry. We got logged out because of weather.
Oh, yeah. Well, the weather's getting pretty rough here, too. You can hear it in the background. Okay. So the other terms and conditions, please make sure you list your addenda that you're going to use. If you don't list it on the contract, it's not a part of the contract. So be very careful. Also, use the 80 forms that we provide. Please, I'm happy to help you through the forms if you need modifications, if you need changes, if you need other terms and conditions. You should not be doing that without your attorney's assistance. That's unlicensed practice of law, and you subject your broker to liability. Let's see here. Joni, you asked a question. Are assessments prorated like taxes or condo fees are? Yes, they are. Seller pays to the date that the property is sold. That's correct. Darlene, yes, provide the code compliance brochure and the energy brochure when you do your contracts. Provide those to the buyer. Very important to provide those disclosures. They're listed in the contract, but they should be provided and they are in your forms folders. Okay, last thing before we get to questions. There's a big wire fraud advisory on your contract. Don't share wire instructions. You should never, as the realtor, never, ever, ever, for any reason, see the buyer's or the seller's wire instructions, because all you're doing is subjecting yourself and your broker to liability. And I hate to say this, but it's always the realtor who gets hacked. In pretty much every case, it's someone using the Yahoo account or the AOL, and they had a simple password because they've been doing it for 25 years. It's always the realtor that gets hacked. There's a big case going on in Collier County. $400,000 from a competitor's title company was wired out of South America or something, and it was the realtor that got hacked. Just be careful. Don't share wire instructions. Okay. Arliss, when listing a condo as is, ask agents to submit an as is contract or add the as is addendum. Yes, that's exactly correct, Arliss. Use the as is addendum or an as is contract. Okay, Joni's asking, where's the best place to get condo docs? Call me, I'll get them for you. Shoot me an email. My underwriter gets them. It takes like 2 days. Very easy. Tina, would it be legal to commingle forms from different associations? It's legal, but it's not advised. It's very dangerous. Don't do that, Tina, because the forms reference different parts of the contracts and they change language in the contracts. So if you have, like, for example, the HOA or condo addendum to the FAR contract doesn't match up with the NABOR contract, so don't do that. Marcus, yes, everyone, I'm recording this. I will make it available on my YouTube channel and you can grab it from there. I think we also send a link to it in our post closing after the show is over. Okay. What is the difference between an addendum and a rider, Katya? Addendum and riders are basically the same thing. They're basically the same. The difference is between an amendment and an addendum. Addendums attach to contracts before they're executed. Amendments amend or change executed contracts. So be very careful there. Other questions, feel free to unmute yourself or put it in the chat. Anybody? I don't see any other questions. Oh, Oh, what lines are the 15, 5, 10, and 5 found, Robert? Robert, the 15, 5, 10, and 5 are found throughout standard D, D2, in fact. There are a number of them. If people have questions about the inspections, I mean, I can do a whole hour on inspections. Call me or email me separately, and I will walk you through the inspection period, and I'll just do that individually for everybody. It is a very complicated situation. Okay, I'm gonna stop the share. Great. Is the contract used outside Florida in the USA? Vivian, no, it's not. It's a Florida contract. It's only for Florida. Okay. Everyone, thank you so much. I'm gonna send a link out to the email. In the email, I will see if I can include the slides. And thank you all very much for your time today. And I will be talking to you all soon, as long as we have no more questions. Okay, I don't see any. Thank you.